Good morning, good afternoon even. So you're all very welcome to this seminar today, Protecting the Messengers, What Every Civil Society Organisation Needs to Know About Whistleblower Protection. So this lunchtime seminar is the second now in a series hosted by Transparency International Ireland and the Whistleblowing International Network to raise awareness about this EU directive on whistleblowing and the implementation and evolution of whistleblower protections across Europe. These seminars are a part of this EU-wide project, which is being implemented by Transparency International, known as the Strengthening and Fostering an Enabling Environment for Whistleblowers across the European Union, which has been made possible thanks to funding by the EU's Citizens' Rights and Values Programme. So many will probably know that whistleblowers are often the first to uncover corruption, which is why many of these organisations are based in anti-corruption work, environmental harms and other public interest threats, which are issues at the heart of what many civil society organisations or NGOs are created to address. However, without strong legal protections and what we call sort of visible allies, they can face devastating retaliation. So the session this morning will explore why whistleblower protection is not only a legal issue, but a strategic concern for civil society organisations working across Europe and beyond. And it will also unpack what the EU Whistleblower Protection Directive means in practice and how CSOs can act as trusted watchdogs, safe havens, and powerful advocates. So my name is Ida Nowers, and I am Knowledge and Policy Manager at Transparency International Ireland, and I also am coordinator of the EU Whistleblowing Monitor. For those that don't yet know, Whistleblowing International Network, who are also represented today, in collaboration with Transparency International EU and EuroCAD, which is the Council of European Professional and Managerial Staff, set up the EU Whistleblowing Monitor, which is an online tool, a website, shortly after the EU adopted this directive on whistleblowing in 2019, to monitor the transposition of it across the 27 member states, share opportunities and learnings about the best approach, and hold their governments to account to do a good job at implementing these new regulations, these new whistleblowing laws. I'll introduce you to the speakers you can see on the screen as we go through, as they are about to share and speak on screen. But before we begin, I must do a little bit of housekeeping. So please be aware that this session is being recorded and we are aiming to make it available on the EU Whistleblowing Monitor website. Please do mute yourself throughout the seminar. If you have a question, you can pop it in the chat and we will aim to get to it at the short question and answer session after the panel discussion. We are disseminating a new briefing paper with a short one-page guide on the EU directive, which my colleague Ed is going to put in the chat just now. This is a new resource that's been developed under this funded programme I mentioned. Please do feel free to share it with other civil society organisations in your network. If you're interested in translating it, then I would be very happy to work with you on that. So please do reach out to me. This seminar will run for 75 minutes. We have a panel discussion, a Q&A, and I'll do a short wrap up at the end. Again, my colleague Ed is in the chat. If you have any technical issues, you can send him a message. He appears as the word WIN. So why should whistleblower protection be on the radar of civil society organisations? So I've listed here on the screen a number of reasons why the EU directive might be of relevance to a civil society organisation. So firstly, as an organisation, the EU directive now mandates many public and private organisations to establish channels to organisations to receive disclosures through these new channels. We know that civil society organisations, for example, those working in environmental protection, Human rights, we'll hear from our colleagues later, have established platforms to receive disclosures on the specific mission that they are working on. There is a capacity to, when individuals reach out to organizations with an issue, with information about public interest harms, to support them, signpost them to the organizations which have developed specific legal advice and specific practical supports for whistleblowers, to make sure that as they go through their disclosure journey, they can have the support that they need. Organizations can use their platforms to amplify disclosures of whistleblowers, whether that's raising concerns about environmental waste, pollution, or tax avoidance, the wide range of public interest harms that individuals may approach organizations with. They can turn this into a collective issue, and by raising concerns collectively as an organization, that can then shield and safeguard individuals who are often putting themselves in grave danger to raise these things. The sort of personal cost, the retaliation of speaking up when there's many people that may not want that information to get out, can, I'm sure as many on the call understand, be very serious. So having allies, including civil society organizations working on that topic, that understand the nature of the concerns and understand the landscape, can be incredibly powerful. Yes, and one a sort of key issue or key reason why we would like to sort of bring civil society organizations to speak with the whistleblower protection experts is also to encourage joining in coalition to advocate for stronger protection. So as I'll explain in a minute, the EU directive is there, we have the national laws, there are gaps, there are challenges, and we know that when working in coalition, particularly across cross-border, we can be stronger together to advocate for reforms and make sure that governments implement best practice principles as they have been evolving in Europe. So we are delighted to be joined by our first speaker this morning, Zuzana Długasova, who will say a few words about the work of the very important organizations who are leading this work in terms of public authorities and their role within the whistleblowing framework and pushing forward best practices. Zuzana is the president of the Network of European Integrity and Whistleblowing Authorities, which have some of us come to call NEWA, and the president of the Whistleblower Protection Office in Slovakia. She is a lawyer specializing in human rights and legal ethics, and before being elected the president of these organizations, she worked as an attorney and a lecturer and a lawyer at the European Court of Human Rights. While Suzanne is talking, we'll share some of the latest reports from NEWA, which may be of interest, so do keep an eye on the chat. Susanna, with many thanks, the floor is yours.
Thank you, Ida. Good afternoon to all of you joining. You are very brave that you're joining such seminar on Friday afternoon. So you must be very interested and motivated, which is great. And thank you, Ida, for inviting me to this event. As Ida told you already, I will speak today in two capacities: as a leader of a national whistleblowing authority and also as a leader of the European Association that today associates 34 national authorities from 24 European countries. So we are growing step by step. When I was thinking what should be the most important to tell you today in my address, I told myself that one story is probably better than many complicated theories. So I'll start with a story, and I'll also add a little bit of theory in the second half. So this particular case that I would like to talk about demonstrates how varied and challenging the reality of the reporting person might be, but also demonstrates different roles of various actors in whistleblowing protection and supporting whistleblowers. It concerned the economist that worked in a state-owned company, ambulance service that fall under the Ministry of Healthcare in Slovakia. And this economist drew attention to irregularities in their accounting statements and also to allegedly manipulated and overpriced public procurement of ambulances. So she filed a criminal complaint, but she also transparently informed his director of the state company. Since then, the course of events accelerated. The employer decided on the need to reduce the number of employees and carried out an organizational change that actually resulted in dismissal of the economist. From one day to another, she practically became a persona non grata, and she only was allowed to enter the building of her employer in the company of a security guard. So she sought help at a civil society organization, a local civil society organization, namely Stop Corruption Foundation, which was able to arrange for her a pro bono attorney. And after the Whistleblower Protection Office started its operation in September 2021, so her case started slightly earlier than actually the office existed. She requested that our office suspends the dismissal, and the office in the special proceedings took arguments of both sides and heard both the employer and the employee. And the employer explained that he offered everything what was available at the moment of organizational change, but the Office of Whistleblower Protection realized and figured out in the proceedings that there was also many other hirings after the organizational change that actually was also theoretically available for economical positions, but these positions were not offered to our employee. So that's why, because the employer was unable to explain that discrepancy, we suspended the dismissal for 30 days. That's what's allowed by the Slovak legislation to suspend the dismissal. And within those 30 days, the whistleblowers turned to court with a request to issue a preliminary measure and also challenge the lawfulness of the dismissal. Finally, court at 2 levels, with the help of the pro bono attorney, with the support of the civil society organization, and also with the intervention of whistleblower office that intervened in the civil proceedings, issued a preliminary measure, and this year, even the second instance courts decided finally that the dismissal was clearly unlawful. This happened after almost 6 years of tensions between the employer and the reporting person. These court decisions, when I took the side back to the history of our start, this is actually among our first most important judicial decisions, and the reporting persons, thanks to the existing domestic legislation, received her full salary pending the outcome of the legal dispute. However, even after that clear victory, the story was not over because the employer refused to get back the whistleblower with the argument that he filed the extraordinary remedy and that he doesn't have any free positions available. So the civil society organization, the Stop Corruption Foundation, together with her pro bono attorney, organized a press conference in front of the ambulance service building, calling on the employer to respect the court decisions. In reaction to the answer of the employer, the Whistleblower Protection Office also started administrative proceedings against the employer, which potentially can end up with relatively high financial sanction. Moreover, our office decided to warn the healthcare minister directly about the unacceptable situation in the state-owned company that the ministry is responsible for. And only after these events, the wall collapsed. And The Economist currently is negotiating with the director of the state-owned company about her new position. So the story tells us a lot about our reality, in my view. It teaches us that the cooperation, especially between the civil society organization and national authorities, is very important and can be even very effective. And finally, it shows that the rules are important, but people are everything, in my view. And now let me touch a little bit also upon the legislative reality that we are facing. The European Directive on Protection of Reporting Persons, many of you might know, but I'll point out that actually it brought to life a paradigm shift, especially in the equality of reporting channel. There is no longer a preference, whether internal or external, no order, in prioritizing the truth and the content of the report over the motivation of the whistleblower, up to the reversed burden of proof, and also stressing the importance of the duty of confidentiality. And so what we do in the framework of NEVA, we have been following how different members approach the whistleblower protection, and now currently we are eagerly expecting the European Commission reflection on the transposition of the directive, as they soon will be communicating with member states about the quality of transposition. But not only that, they are also under obligation to come up with a review of impact of the existing legislation and potentially also with proposals for amendments and hopefully also for adding some higher quality to some effective legal measures, which we think that are not fully, let's say, ideal. To give you an idea on how different national whistleblowing authorities are, I'd like to share now with you an interesting slide. Thank you, Aida. This is, I call it a butterfly picture. And this is thanks to our great analyst that we have in the Whistleblower Protection Office. And back in 2021, based on the detailed information from NEVA members, so the national authorities across Europe, they created this chart in which you can see how different the competencies on different specific activities across Europe exist in whistleblower protection. So you see that there is a relatively high number of organizations that receive whistleblower protection, compared with very low number of organizations that deal with protection measures or psychological support. So you see on those numbers, the prevention and education relatively high, but protections and support is not that strong. And this I see also that there can be an area where civil society organizations and national authorities can effectively cooperate. So despite the heterogeneity, we deal with common topics. And in this moment, I would like to highlight a couple of issues to give you an idea what we discuss within NEVA and what we see as potential, or not only potential, but also real challenges. For example, NEVA strongly recommends and supports the idea of psychological or emotional support. We see that there are stages when emotional support is even more important than the legal one on the journey of a whistleblower. To give you a little bit of numbers, sadly, only 3 national authorities out of 33 reported to provide some kind of psychological service. So we see that there is a really room full of opportunities in this area. We also see vast differences between level of protection provided by individual member states. Some states only provide judicial protection, which in NEVA's view requires at least tailor-made training for judges. Some other states have more opportunities to protect whistleblowers. States often fail to protect those who work for the state, such as civil servants and police officers, because they do not have equal remedies against retaliation for employees in private and public sphere. This actually leaves us with a paradox that those who deal with sensitive issues or highlight sensitive issues do not enjoy the same level of protection as the private employees. And finally, I would also like to mention sanctioning areas. EU countries' sanctioning system in whistleblower regulation are dramatically different, starting from criminal offenses, which are not very much used, but they are on paper, and strict administrative sanctions through relatively low sanctions that cannot be called discouraging, and ending with no sanctioning powers at all for breaching confidentiality or retaliation against whistleblowers. And we could go on with other challenges, including politically motivated attacks on whistleblower national authorities, but I'll leave that to another occasion because we have some time restrictions. So in this very moment, I would like to leave you with 3 main points. So the first one would be cooperation, especially between civil society organizations and national authorities, are vital, both in lobbying for high quality regulation or in supporting individual cases. For example, just our local example, our office would most probably not exist at all without civil society organizations' engagement. And thanks to the civil society activities, we have the legislation that we are currently enjoying. The second point would be training matters. This is kind of obvious, but I would like to stress one point, not only for those who deal directly with whistleblower protection or support, but also to those whom whistleblowers might meet on their journey, especially from my personal experience, police officers, prosecutors, and judges. And in terms of capacities, I would like also to share another number. For example, NEVA numbers shows that the mean number of staff members allocated to educational activities is only 4.3. So there is also a huge room for joining forces and capacities to train all those that might need that. And the very last point, finding dedicated people to deal with whistleblowing agenda is crucial. Thank you for listening.
Thank you so much, Susanna, for those very important and very insightful opening remarks. Thank you also for highlighting so clearly this important synergy or possibility for collaboration between the authorities and the civil societies. I know that you are, I love to hear that you are such a proponent for that. Of course, that's not always the case, that the authorities want to engage so openly with the NGOs, and so it's been amazing to see your offices doing this. So thank you very much indeed for joining us. I should quickly go back one slide just to point out that information about the network of European integrity and whistleblowing authorities has been available on the EU Whistleblowing Monitor for a few months. And just yesterday, we now have a new website. So you can see who is participating in that in your country, who is the sort of leading authority that's engaging in the network, and the governance board, and some of the founding documents and reports. A couple have been shared in the chat. So again, thank you very much, Susanna.
We'll be updating soon, so there are not the latest information, but it will be soon updated. Thanks.
Thank you so much. I am grateful to Susanna also to start talking about the key elements of the directive. And I thought before we begin talking more in detail and sharing insights on the directive, I might just give a little bit of background. So this directive was passed towards the end of 2019, and the member states had 2 years to adopt legislation or transpose, as we say, these new minimum standard requirements into their national legal systems. And all 27 countries have now adopted new legislation. There were 8, give or take, that already had a law. Most didn't, or didn't have a comprehensive national law on whistleblowing protection. In terms of thinking about these European laws from a global perspective, they're pretty much agreed to be groundbreaking in many regards. I'll go into the sort of leading or key elements that are of interest, but its transposition, its implementation is really important. The devil is in the detail, as people say. And a lot of people on this call have been involved in looking at these laws and again, trying to push for them to be workable in practice. And of course, NGOs have a very good insight on how laws are being implemented on the ground and can feed into that analysis and to the advocacy to make sure these do what they're supposed to do. The aim of the EU was pretty much to harmonise protections. I think I could say that it's questionable whether we are in that position because member states took a very different approach. Some were much more progressive and really went above and beyond the minimum standard, particularly in countries where civil society organisations were actively involved. We'll hear from Simona later about the template law that was produced at an early stage to sort of set the tone for legal negotiations. And in France, another country, a sort of a collaboration of civil society organizations with the unions also led on a kind of CSO-led draft law. So we've seen that be particularly helpful in creating more provisions which, as I said, go beyond these minimum standards and are trying to introduce something more creative or more innovative. We had last year, Susanna mentioned, the compliance report. I think it's fair to say there's some very serious gaps, and we're a long way off from saying that all of these countries meet even the minimum standards. And now in 2025 and beyond, we have just last week or the week before announced the evaluation process. So there will be a public consultation and a huge amount of work sort of engaging again with CSOs, with unions, other key stakeholders to understand, are these new laws working in practice? And just to mention, the Commission in their to their benefit, to their strength, if you like, did take very early action when it comes to overseeing the transposition, in that they very quickly started infringement proceedings against member states that had not communicated what they had done to transpose this directive. And we had just last year a hearing or a judgment of the European Court of Justice, which fined 5 member states a huge amount of money, totaling just over 38 million euros for the delays that we saw. So that's the sort of EU background and context. I think I'll move on now just to share. It's very difficult to put the huge amount of provisions and significant requirements of the directive into 2 minutes, but I find it useful myself to split them into sort of 3 categories. So we have now this new network of reporting channels, mandatory reporting channels in the private sector, the public sector. Those are internal, that is sort of employees speaking up about wrongdoing in their own organization, but also, and this is quite groundbreaking in some legal jurisdictions, external reporting. So that means that whistleblowers can go directly to authorities, not have to raise it first with their employer. And of course, protection of public disclosure. So there are now strengthened in some member states protection of those reporting to journalists or to organisations that aren't the prescribed external authority. And again, that may be civil society organisations. There are more robust protection measures. So this includes, as a cornerstone of the directive, protection of identity, and as Susanna mentioned, some sanctions to back that up, at least in some member states. Quite significant immunities from civil and criminal prosecution. That means that if you're making a whistleblower report, you're making what we call sort of disclosure, protected disclosure, as it can be called, you wouldn't be able to be prosecuted or fined for doing so. And also full remedy. So that means what we call sort of make whole compensation. So if you were to suffer financial losses for making a whistleblowing report that was covered by the directive or the national law, you would be able to go to court and have quite beneficial or progressive conditions for the protection in terms of you would benefit from a reversed burden of proof. It would be the perpetrator of the retaliation who would have to prove that they didn't prosecute you or didn't harass you for making a disclosure. That's quite a novel and impressive sort of legal standard within the directive, and then also interim relief measures. So that's to say, we see this package, if you like, of quite impressive protections for people making disclosures. And then the third prong of that would be these sanctions and supports. Susanna mentioned they do vary. Sometimes the sanctions or the penalties for making a false disclosure are actually heavier and more dissuasive than those that are in place for not putting in place channels or breaching confidentiality or retaliating. But the directive is clear that there should be repercussions for these breaches. And in some member states, to give an example, you could go to prison for 2 years for breaching confidentiality. There is then a slightly less well implemented provision in terms of support measures. So some of the NAWA organisations and the organisations on this call are providing legal advice to whistleblowers, psychological support. In some countries, there are measures to help whistleblowers make media disclosures, so sort of media assistance. It's different across the different jurisdictions, but that's a sort of key tenet, that whistleblowers should be able to access legal, financial and practical supports when making a disclosure. The scope of this, it's quite broad in terms of who can report. It's not just employees, it's extended to volunteers, to shareholders, and it's also important for this audience been extended to facilitators and third parties as well. So those that are supporting whistleblowers, that indeed may be an NGO, and some member states have the same protections, or at least some protections, when assisting with a whistleblowing report. And what is protected, again, that varies quite differently across the member states. The EU could only mandate these laws to cover breaches of union law. That's quite wide. Some member states took the encouragement to expand that out to breaches of national law. Some have gone even further to extend it to anything which sort of harms the public interest. But again, it undermines the harmonization, but the idea is that it would be quite broad. If you're reporting something within the scope of the law, then you would benefit from all the other protections. So what key changes would be of interest to a civil society organisation? These new confidentiality guarantees and anti-retaliation measures arguably could mean that there may be more disclosures. So once whistleblowers or the general public become more aware of the rights that they have under these new laws, they may be more willing to speak up about information which is relevant to your missions. We have the expanded reporting rights that gives more options to whistleblowers when they're considering where to speak up. We talked about internal, external, and indeed public disclosures. And in some of these laws, that may include protection of reports made to civil society organisations, although that may be conditional, a sort of higher standard that they would be required to make such reports. I mentioned these facilitation rights. There's at least some protection for organisations and individuals who facilitate disclosures, support or assist with making whistleblower reports, and then advice. So what I mean by that is that there are sort of new opportunities, for example, funding for organisations to provide these support measures, whether it's setting up legal advice lines, as is the case in Ireland where I currently work, or providing support and guidance, for example, through unions. So that's a whistle-stop tour of these whistleblowing laws, which leads us onto a panel discussion, if you like. So I'm going to introduce to you 3 speakers who are all very much leading voices, coming from whistleblower protection organisations. These are CSOs which are dedicated to public interest whistleblowing protection, whether it's working with whistleblowers or advocating For change. So, in no particular order, we're delighted to have Simona Levy, who is a multi-talented activist, strategist, and writer. I know her above all of these wonderful things that she does as being a leading voice for the Whistleblower Protection Directive and in monitoring and pushing for robust implementation, particularly in Spain. Simona founded XNet, which is a digital rights organization, and has a lot of experience developing secure reporting platforms that are now used by hundreds of institutions across Europe, setting standards for protecting whistleblowers and strengthening democratic accountability. We also have Anna Myers, who I've worked with previously, who is a good friend and a lawyer, and also executive director of Whistleblowing International Network. We call this WIN, and it essentially is a membership organization which connects and strengthens the work of whistleblower protection organizations across the world. There are around 14, if I remember correctly, organizations which are core members. These are all providing direct access to legal advice and support to whistleblowers, and then a vast number of others who are working in advocacy or research or investigations. So she oversees this organization that's become a sort of global hub of expertise on whistleblower protection. And then last but not least, we have Gabriel Bourdon Fatal, who is Director of Climate Whistleblowers, which is a fairly new organization dedicated to protecting whistleblowers reporting environmental issues. Gabriel has been working in this space for a very long time. I was previously, or still is, project manager and then director of programs at the Platform to Protect Whistleblowers in Africa. So 3 very esteemed speakers. I'm going to work through a few questions. And my first question is for Anna. So Anna, from your experience in leading WIN, why should whistleblower protection be a priority for civil society organizations across these different sectors, whether or not they see themselves as directly involved in this space?
That's a really great question, and thank you very much for organizing this and for those attending, and of course for the speakers, other speakers. I feel like Susanna kind of covers so much, but I'll pick up on some of those issues. I think, well, civil society being engaged, and certainly the local, the national organizations that pick up whistleblowing and worked with whistleblowers for many, many years. One of the key aspects of why civil society is so important is in navigating how someone would speak up. And so thinking about the public interest and the public interest in the information being addressed and being dealt with. And then what are your options if the normal channels that you would think would work don't work, means that they became, and the ones that started before, there were many laws around the world, became experts in how power works. And they get to understand really the systems in their countries, the institutions in their countries, and how you have to work across the board for protection to work. As lawyers, and there's probably a few on this call, and certainly in my experience, and I love to quote Tom Devine, who many of you know as a U.S. lawyer who's a world expert in many ways, or at least has gone around to sharing his great expertise around the world. If all you have is the law, then you're a bit screwed, because the law does not walk with you the next day into whatever situation, but the law can guide you. So the specialization that the CSOs that worked on whistleblowing, started, they might have come from a consumer protection background. They might have come from a transparency or anti-corruption background, but as they had to actually navigate these systems. And some of them focused only on whistleblowing wherever it came up. And I think that issue meant that they understood it did call on, as Susanna said, an array of actors, and it still does. The fact that the laws might be improving, and the fact that some of these provisions can be much stronger, it is not ultimately ever going to be an instinct of power to be really focusing all their efforts on how they can be questioned. And how those systems work to back them up. You have to, we all know if we work in the field of whistleblowing that you flip that narrative to say how important it is, because when you don't, look what happens. And we have so many stories and so many situations where those in power get caught out not even always for the wrongdoing, but the failure to act. And so it's the fact that that civil society calls them to account, calls them to explain their conduct, which is important at all levels. And the CSOs who are not working directly with whistleblowing will be doing that in their own ways, whether they're doing research. So a lot of the ones that over the years that would become interested is that they were starting to realize when they were doing research, surveying people and sources, these are not even investigative journalists, that these people that they were talking to might be taking risks sometimes in giving them that information, or might be actually in positions where, wow, it was a lot more complicated. It's not just surveying a group that is experiencing it, something to themselves, and therefore you're finding out data for other people experiencing the same things, although in some ways we do that with whistleblowing. These were people who were trying to do something sort of bigger than themselves. It really sometimes didn't even mean that it was like they wanted to be happy in their jobs and do good work, but they were being told to do something wrong. So CSOs, over the years, we would get contacted, the few of us working in national organizations, we'd get contacted by CSOs who were like, oh, we put out this big, report about environmental issues and these issues, and people are calling us with information about these issues. And we don't know what to do with them because these are live cases. The same would happen with journalists. Sometimes journalists would come to the CSOs because they wanted to talk to some whistleblowers, and so they just want you to give them whistleblowers. But some would come because they were like, oh, they're starting to become more aware, and there are always some very, very good journalists doing this, but I think there's still some tension for journalists in the fact that the story was going to add to problems for the source. That would be problems that they wouldn't be able to address, and becoming more alert to that. So what we saw in Europe in particular, and sort of focusing on Europe, is that there was a buildup of a number of things that meant that by the time we had a trade secrets directive, some of you will remember, there was a sudden acknowledgement really that what was also happening was information was being privatized, and those who would normally not have been necessarily in trouble for sharing information outside of organizations were going to get in trouble. And the trade unions picked it up very much because people might be moving to a different organization and suddenly couldn't take their expertise with them with this wild trade secrets directive that kind of made it private information that only rests with the organization. So they were like, this can affect the movement of our people. And what you found in the build-up to the EU directive was this coming together in a way that I had not seen, because in many countries, the civil society had been working on it, had started to really change the narrative around whistleblowing, started to make it known that there were some options, started to get government and lots of other organizations interested. And that will always need to happen, because even with the law we have now, and as I was saying, there was this buildup, there was a different, we weren't the only ones in the room. It wasn't those who dealt with whistleblowers, which, we can start to seem like the usual suspects. We had a whole group of NGOs and CSOs, trade unions, journalist associations, the anti-corruption movement, coming together in a platform to really push for whistleblowing laws and to have a directive that would meet a standard. The whistleblower protection specialists were able to really turn the experiences of whistleblowers into the provisions that needed to be in there. And that experience is going to matter. Climate whistleblowers, AI whistleblowers, these are new things that keep coming up. I think that the playbook of whistleblowing and retaliation is probably really similar, but there are new challenges, new ways of talking about it. And these organizations are starting to come and think about whistleblowing much sooner than they did before, when, for the longest time, people talk about corruption, but they were not thinking about the individual whistleblowers. And in the end, it's the people, as Susanna say, that matter. It's the people that see what's going wrong early. And so all the CSOs in this field started to really come together. And WIN was part of being able to, quote, take advantage or realize that there were more organizations that needed to be talking about this space much more clearly when we developed WIN. So to me, the role of CSOs and why those who might not see themselves directly involved, I think they, I think they'll get a whistleblower at some point, and then they'll be scrambling to figure it out. I think in Europe, they might not scramble as much as they did before, because there's information out there. The internet has made it available. there are organizations, so they do start to find out about it. And when they're interested, I don't think you can turn that off. I think once the organizations that see whistleblowing in that light as at the public's right to know, people giving information that they should be allowed to give, they stop seeing it as not part of their wheelhouse either. So I think that civil society remains absolutely key, and that we need more in the room, and not fewer.
Yes, thank you so much, Anna. So I guess in the you've touched on there sort of your experience of working in this, for the bird's eye view from the global level of organizations contacting you and contacting these whistleblower protection experts. I wonder if we turn now to one of those organizations. So Simona, you are a participant in WIN. Presumably you have a reason why that is so. Could you tell us a bit about why you considered it worth the time, or what was your incentive to get involved with WIN, to get involved with the advocacy for the directive, and to push for good transposition of the whistleblowing directive? Thank you.
Hi, everybody. I am very happy to be here and to see all these fighting colleagues also between the participants. In fact, in Spain, we work on digital right, but on digital right in also the sense of using the internet as a tool to improve democracy. So we do a lot of different things, and one of the most important thing we have done is via a digital device, organizing the civil society. We lead to conviction of 65 politicians and bankers, 15 of them in jail, one ex-minister of economy, a former minister of economy, a former president of the International Monetary Fund. So we did all this only by organizing civil society with the internet. And so we were really pioneers on creating channel to receive information to do our work on anti-corruption. The work on whistleblowing in Spain is really, when we started this, that was around 2010, 2012, we were very little people talking about that. Basically, we did the first document on that together with very few other organizations like iDerecho, and we did the first draft on asking to our institution to start working on the subject. This was on 2010. We opened our first channel using Google Global Leaks technology. We opened the pioneer channel for anonymous information in order to start this court case I've told you that lasts during 8 years. And what happened is that this channel that we opened just for our own case, a case of corruption in banks and political parties, start being the channel for the whole Spain to leak information, mostly around corruption, but not only. So clearly, we were the only space where that was safe to send information. And in fact, most of the time we receive, at least 50% of the time, we receive information that was sent to us after being sent 2 or 3 years previously to the official Spanish judicial system. So the prosecutor or the police, police or other entities. So we really saw that there were a problem. Of course, we have a budget of 100,000 euro per month, per year. So we cannot afford to be the organization, and in general, civil society in Spain, we cannot afford to be the organization taking care of such a complex thing. We did it in any case. For many years, we were helping whistleblower on technology, on protection. We were bringing the information to the press. We were bringing the information. And so we solved many other cases together with the civil society. And today is the day of today we speak about civil society, and yes, what I can say from my experience in this case is that it's very important that there is an engagement from both sides. So, for example, one of the rules we had in order to help or not a whistleblower in this case, since we had really too many, was if the whistleblower was there to help, not to expose him or her, but yes, to be as active as we are, because this was done pro bono, of course, and with a lot of problem and threats, etc. So this is why we decide, of course, that a directive was necessary. So when the European Parliament started working on that, we, of course, wanted to help. And so we met all these marvelous people like Anna, like you, like other people. So altogether, I think this is one of the law that was really, as was said before, really pushed by the effort of the civil society. So what I have to say from my perspective is that we have a bit of a romantic idea of whistleblowing. And I think this for us was very much a problem, because we thought that whistleblower means someone nice that want to help and want to change the world for better. But sometimes it's just someone in a difficult situation because it was just working, and or he or she was just working and have to decide to be a corrupt or not. And so so I have no other chances. So you have no choice of being an hero or not. You can be or corrupt or hero. You don't have a middle choice. And so this implies, so I agree what Susanna said before. This implies also that you have to understand and to help and to work on why people make this choice, which is something that require as much effort than to use the information that they were leaking in order to solve a case. So it's of course very necessary to not put in the same box the intention and the importance of the material. We have in our circumstance, in our box, we can say that there were a 40% or 30% of people making this difficult choice, forced or by choice, but with the willing, really, that say, okay, I have to be an hero, so let's go for it. And taking this decision and helping this decision. But there were also a higher quantity of information arrived, for example, for people that were involved in some clients' power forms, that they were just wanting to kick someone, some other person in this network of bribery, or in any case wrongdoing. There is a lot of love stories involved, and this is not anecdotic. It's really a part important of this work. So what I always try to explain is that, first of all, we cannot take this as a civil society, because have to be the institution to do this work. So we have to put a lot of effort in helping the institution to do the right thing, in order to, because up till they don't do it, we have to do it. So we have to really help institution to do the right thing. So from one side, we have a problem that the situation of whistleblower is not like a simple human situation. It's a very complex. And from the other, we have the other actor that have to be taken in account is the institution, because as it have been said just before me, often the institution is resisting, doesn't want this law. In the case of of Spain, for example, the institutions are really hostile to this. The government is really hostile to this law. And without the EU, we couldn't have any such a law in Spain. And we are proud to say that it's one of the worst transposition that we have in Europe of the directive. So there is a long path also in order to that we can really shift all this work that have to be done to protect the people from the civil society to institutions that are really willing to protect whistleblower. And so to end up on this part is, this is why, and I will explain this maybe later, this is why the core thing when all these two poles are still very complex and not very solved, important is the protection of identity, because it's something that can protect the whistleblower in any circumstances. So the whistleblower protect himself or herself if we can establish strong protection for the identity and the anonymity of the person who leaks and who to bring to the public some important information.
Thank you very much, Simona. And you raised a couple of points there. I might just flag, bringing it back to sort of what the directive says. It's very clear that the motive of the whistleblower shouldn't be relevant to whether or not they receive protection, which was quite a move forward in terms of some of the other laws, which have long focused on this concept of good faith. In the interest of time, I would like to follow up with each of you. I will try to do so if there's no questions. I'll just turn to our third speaker. So Gabriel, you've worked extensively with PALAF in Africa, and you recently helped launch this Climate Whistleblowers platform. What made you feel it was necessary to create a dedicated space for environmental whistleblowers, and what distinct challenges might they face that existing protection systems weren't already addressing? Thank you.
Thanks, Ida. I think it's quite nice because so much has been said. That's exactly what I wanted to say, so I can be a bit shorter and I think exemplify a couple of the examples with our case of climate and whistleblowing and why we think the directive is an incredible boost. Because we think that whistleblowing is a natural boost for every civil society effort. It can reinforce whatever you're trying to do in public interest, but the directive has been an extra step with that. And the directive was part of the reasons we decided to launch this organization. I think a couple of clear reasons why we decided to launch Climate Whistleblowers is, well, first of all, climate is really important. I don't think I need to expand on that. We need every effort to fight climate change. There was no organization dedicated, and we saw it as important. Another reason is that we saw people as particularly prone to blow the whistle on environmental issue. People are pissed, they are frustrated, they're mad. Every poll shows that a big amount of citizens and employees are really mad about what's happening with climate, more than we think, and they want to act, but they don't really know how. And climate action, political action, or individual action, or citizen action is complicated. And we saw whistleblowing as a good complementary action to that. Another reason was the directive and whistleblower laws worldwide. So in general, we can see way more whistleblowing protection laws. But this new wave of laws is incredibly beneficial for climate and environment, right? First of all, because many times environment and climate are mentioned specifically, well, environment, not climate. So it creates a legal basis for people to come forward and blow the whistle on climate. But also because blowing the whistle is this particular extra thing that you can blow the whistle on something that is in the public interest, but not illegal. And so very often actions that are going against our climate and against our future are against our public interest, obviously, but they are not yet still illegal. Two last reasons I'll give. The first is climate whistleblowing specifically we thought was extremely tricky because you blow the whistle on very strong and powerful forces, the same forces that oppose climate action, and it can be big politicians, it can be big fortunes, and it can be fossil fuels, but all of these powers are extremely dangerous and scary to blow the whistle on. So we thought there was an extra gap there that needed protection. but also because it's so hard to prove many times environmental fraud. If you pollute a river, very often there will be no written trace of your crime. If you do emission fraud, you will need to actually test emissions and test the air and test the water. So you need another layer for the whistleblower to be able to prove that he was right, that he or she were right when blowing the whistle. So another reason why we're here. And more generally, I think we just said the directive needs to be implemented by civil society, by authorities. So there was a victory with implementation, but now there's many other victories that will go through little cases of jurisprudence and fighting in Slovakia or in France or in Germany, etc. And climate is at the same stage, basically. Huge amount of environmental and climate regulation is, well, not really binding, but even if it is binding, it's very recent, and we need to put it to the test. So we thought that combining these two, we need to go the extra step by having a civil society organization that takes these cases forward, and by working with authorities on both the issues, help push these kinds of whistleblowers.
Thank you, Gabriel. Yes, it's really interesting. I've been very following the work of climate whistleblowers and, of course, of the platform to protect whistleblowers across Africa. Thank you for your intervention. We are a little behind on time. I did want to have a second round of questions, but given the time, I wonder whether I might just pose the same question just for a sort of 2-3 minute reply. We're hoping that the audience today are civil society organizations that perhaps haven't worked with whistleblowers, are interested in the topic, but haven't yet started programs or learned much about the topic. For those in Europe, what do you think are the biggest gaps or opportunities to push for better implementation or to start programs on whistleblower protection? And I'll put that question first to Anna.
I think that the issues around I think it's at the national level now. So it has to, those tests that Gabrielle's pointing out, we need to show exactly nationally where they're not working. I think the thing that is frustrating for those of us in the field is that the directive was based on a series of provisions that we think are all important, that they all actually have value. And so when one is not working, that's the one that will throw the whole thing off. And that's the one where there's failures. So I think, and then of course, if they've done minimum, then they're not doing it. So to me, it's very much in civil society, it can't just be the whistleblower protection organizations, because there are so few of them. Still, because it is a hard space to fund, it's a hard space to do, it's transversal, it covers all sectors, it's a difficult area to keep going on, and the ones that do are very committed, and the ones that have been picking up as part of other things are great. So it has to be a group effort at the national level, because those are the tests that prove that all parts of the EU directive should be implemented robustly.
Thank you, Anna. Yes, and I'll pass that question over, throw it to Simona, if I may.
Yes, I have to reinforce the fact that since we cannot guarantee that even with a law in the national state, the authority are doing the right thing, really protecting the people and really implementing sanction and really avoiding retaliation, which is not really happened up till now, not strongly enough. I have to, and with very short time, I think the priority is to take care that the channel have the technical requirement to really protect the people, because this put the whistleblower in a condition that, for example, in our case, we don't know the identity of the whistleblower that permit us to open such a big court case. So we protect the whistleblower because we don't know who he is or she is. So in case that we, so this is have to be a priority. There is the solution. Basically, you can use global leaks and use Tor, which is very cheap. It's open source and everybody can put it in their own organization, or as we did, work with institution in order that in the institution they use really strong technical mechanism that permit really a real protection. And we have to help the institution understanding that anonymity is not something against them, is even to protect them and to make a more hygienic space for everybody in order to fight together against corruption, wrongdoing, etc., etc.
Yes, and I think that just to say on that point, regards global leaks and the establishment of these reporting platforms, that the directive sort of left it open to member states whether they were going to require these reporting channels at the external and internal level to facilitate anonymous disclosure. They do have a clause which says if an anonymous disclosure an anonymous whistleblower is later identified, they would have the same protection. But it was such a hot topic, it was left to member states' discretion. And exactly as you say, there's a lot of work now to show organisations that it's actually in their interest, and they can't just close their eyes and their ears when they receive information just because it's from an anonymous whistleblower. And there are now, through all of the good work that you've been doing, and these reporting platforms can enable two-way anonymous communication to build relationships, to increase confidence and trust. Anonymous whistleblowing, even though it may have some limitations in some cases, is something that should be embraced a bit more. And something we haven't touched on, of course, is those kind of cultural connotations of whistleblowers, and anonymous whistleblowers can rub up against some of the stigma and the negative stereotypes of whistleblowing. But again, in the interest of time, I'll throw that question again, if I may, to Gabriel.
Yeah, I think I'll try to give an example from the African perspective about the directive. I think what happened in Africa has around 10 whistleblower protection laws, and the first whistleblower protection laws were copies of pretty much the UK law that went to South Africa and Ghana and then Zambia and other countries. I think what we witnessed is that the elements of the European laws that were copied and they were a bit weaker were disastrous in Africa, basically, because if you say whistleblower has to go to an internal whistleblowing first, internal disclosure, or that anonymous disclosures are not allowed, that's already really, really bad in other countries because they will get retaliated against. But in Africa, it might mean they will get arrested or tortured or killed. And we saw whistleblowers that felt committed, not only because of the law, but also because of the law, to go to their boss first. And that was a disastrous decision. And I think what's happening now, which is nice and very beneficial, is we see the directive being as a new influence for reforms of laws or for new laws in Africa. So that means a couple of the good practices that the directive identified are now being discussed and reproduced also on the continent. So of course that's not enough, and there's other efforts needed, but very often we see the directive having an influence that we hope will save life in the years to come.
Yes, and you raise a point there about whistleblowers, that we speak in Europe of sort of the risk to whistleblowers being of workplace retaliation or losing your job, but of course it can be much more serious consequences in other regions and in Europe as well. And perhaps there's a bit more work to do when it comes to safety of whistleblowers who are fleeing persecution in very unsafe environments. I've seen some proposals to strengthen sort of asylum regulations so that whistleblowers could seek safety in European member states. And one thing that we haven't spoken about potentially is the sort of the collaboration between member states and these external authorities for protection when whistleblowers are being sort of persecuted, and they have protection, or they're even working as protected witnesses in one jurisdiction, but then they're being targeted in another. And what we know is where there are gaps or risks to whistleblowers, they will fall through those gaps. So a sort of next piece to not just have harmonized laws in each country, but sort of more joined up measures to ensure that whistleblowers can survive the process. Well, thank you very much to our speakers. I'm very sad to be running so low on time. I do want to just take a minute to present this new EU whistleblowing monitor. I'll put a link in the chat. As I said, this has been running since 2019. We very much hope it can act as a platform to enable this collaboration between those working on this topic and those perhaps that are not and just curious. We have, over 30 voluntary country editors now who are all watching this space, looking at the laws, looking at cases in the courts and in the media, sharing information. And the idea now, as we move from talking about transposition more to implementation, is to enable citizens to go on to understand whether the law is good, where perhaps there's some weaknesses, but also where they can go. So there'll be a lot more guides on what the whistleblowing law is, who the external authorities are, who the civil society organizations that might be close allies for them are. We have some new functionality on there. We have a new dashboard, which eventually will be populated to help citizens understand how good their law is. There's also a compliance timeline if you're interested in the chronology of when member states have passed laws, when they're being reformed, and indeed these infringement proceedings from the Commission. There have also been some civil society organisations which have made their own formal complaints to the Commission about some of the weaknesses in the law. So there's a lot going on. There's now also national pages. I'll just present that now. So you can go on and find resources specific for each country and those updates as they come through as well. So I hope that this has been informative. There's been a lot of information. We'll post the briefing again in the chat and we'll share it all with you via email. It is a sort of call to arms to those that are interested. Please do reach out. We've put the link to Win in the chat. As Anna mentioned, she's very used to new players in this space reaching out and asking, who do we speak about setting up a reporting platform? Where can we find information about best practices? What is best practice? WIN has a resources library on its website where you can find everything from studies, journals and articles to tools. There's a number of compliance tools which are sort of setting the standard for these internal and external arrangements. So there is a lot of information out there. And just in the last few minutes, I must save some space to ask you to please complete this donor survey. We are mandated to encourage you to do so. It really is very helpful. You can take a picture of the QR code on the screen, or I'll copy and paste the exact QR code here as well. So whilst you kindly do that, I'll take a final moment to thank all of our speakers today, to Susanna, to Anna, to Simona, to Gabriel. Thank you very much indeed for joining us. And I do very much hope that this quite quick summary of the directive and what CSOs can do, what the directive might mean for them and their work, has been valuable. And as I said, please don't hesitate to reach out. Wishing you a lovely rest of the day and a lovely weekend ahead, and take good care of yourselves.
Thank you, Ida. Thanks, everyone.
Yeah, thanks very much.
Bye.
Bye-bye. Thank you.